A search feature is also available. In addition, court notices, proposed rules, committees, members, agendas, and minutes are also found on this website. This is Justice Lisa Fair McEvers at the North Dakota Supreme Court. You have reached the proper location for live webcast for oral arguments of the Supreme Court. The live webcast from the North Dakota Supreme Court will begin at the time scheduled. The Court's daily calendar is noted at the top of the Supreme Court's homepage. Oral arguments are normally scheduled at 9:30, 10:45, 1:30, and 2:45. 50 minutes are generally set aside for oral arguments. Arguments may go a little bit longer, and sometimes not all the 50 minutes are used for the oral argument. No decisions are announced at the oral argument, as all cases are taken under advisement. The Supreme Court will issue a written decision, usually within a few weeks of oral argument. Written opinions are posted at the Supreme Court website. Anyone can subscribe to receive free email notice of new opinions and other Supreme Court news. Simply click on subscribe on any website page. The North Dakota Supreme Court is the highest court in the state of North Dakota. It reviews the decisions of trial courts, known as district courts, and decisions from administrative agencies. The Supreme Court also decides cases involving the disciplining of lawyers and judges. There is no jury in the Supreme Court, and no witnesses are heard. The Supreme Court consists of 5 justices who are elected for 10-year terms. When there is a vacancy on the Supreme Court, the governor may fill the vacancy by appointment from a list of candidates submitted by the Judicial Nominating Committee. The Chief Justice is elected to 5-year terms by the Supreme Court justices and district judges. The Chief Justice is the administrative head of the state's judicial system. The Chief Justice is assisted by the State Court Administrator and other staff. The Clerk of the Supreme Court receives documents for the Supreme Court. The Clerk supervises the Court's records in the filing, distribution, and publications of the opinions of the Supreme Court. The Clerk of the Supreme Court is appointed by the Chief Justice with the approval of the other justices. The Supreme Court adopts rules used in the state's courts, including rules of civil procedure, rules of criminal procedure, rules of evidence, rules of juvenile procedure, and rules of appellate procedure. All the rules adopted by the court are found at its website. In addition to live webcasts of oral arguments, archived copies of oral arguments are available on the Supreme Court's website. The North Dakota Supreme Court's website contains
All rise. The Honorable Chief Justice and Justices of the Supreme Court. The Honorable Supreme Court of the State of North Dakota is now in session.
Good afternoon, please be seated. We're here at the time set for oral argument in file number 2026-0010, State of North Dakota versus Dreshun Boynton. Sitting this afternoon are Justices John Jensen, Douglas Barr, and Mark Freese. Unavoidably absent this afternoon is Justice Jared Tufte. He will be participating in the argument based on the record and the recording of the oral argument. And I am Lisa Fair McEvers. Ms. Kraus-Barr, you are the only one arguing this afternoon, so when you're ready, you may proceed.
Good afternoon. May it please the court, I'm here representing Mr. Boynton. There's one issue before the court, and that's whether the district court committed obvious error because it failed to establish a sufficient factual basis for the change of plea. This was a case of false information to law enforcement. Mr. Boynton was a passenger in a vehicle that was stopped. Law enforcement asked for his name. He gave a false name, and he was charged with false information for that. The issue becomes there was no basis for the statute requires two things, that there must be false information, knowingly giving false information. That's the first part of the statute. The second part of the statute is that it may materially mislead an officer in their investigation. We don't have any information about if there was an investigation ongoing, if the officer was materially misled. Material is kind of doing a lot of the work here. I know in the state's response or in their brief, they say that it was to conceal his identity. Again, to what end? There has to be a purpose. So there has to be, how is that material to what the officer was doing? And it's not in the affidavit of probable cause or in the original criminal complaint, and it certainly wasn't in the factual basis for the change of plea, which I think I cite directly in my brief. On paragraph 8 from record 86, page 2, where the court goes through. It says on August 7th, 2023, you in fact gave false information to a law enforcement officer wherein apparently you provided a false name to them. Yes, sir. So again, no one's disputing, I guess, the first part of the statute, which requires that he gave information that he knew to be false. Everyone's in agreement with that. Well, we don't have any facts supporting the second part of the second element that's necessary, that this was materially misled or, that there was an investigation where this information, again, was material to that investigation. And the state doesn't really respond to that other than to say, well, he's trying to conceal his identity. Again, there has to be something there has to be an investigation. Some facts to determine why that's relevant. There just aren't any. There's nothing in this record that shows why it mattered, why it was material in any way. It's the entirety of the argument. I don't know how else to frame it other than, they could have added or supported the record if they needed to at the change of plea, saying, well, they were. I can only hypothesize because there's nothing in this record that tells me what police might have been investigating or how they were misled.
You started your discussion this afternoon with indicating your client was a passenger in a motor vehicle. Where is that in the record?
I actually think he tells the court at the change of plea where he said, I wasn't even driving.
He says he was a passenger?
Yeah.
And then my second question to Ms. Kraus-Barr is that the materiality, does that go to the element of misleading? Because the statute says may materially mislead or may interfere.
Right.
Is it either interfere or mislead?
It says, well, the statute says or, so it could be one or the other, if that's what you're asking. I don't think there's facts for either. So I guess I call that element 2 because it's an either or. They can prove it either way. And my review of the record, I don't think they proved it in either instance. So there's certainly no indication that there's any investigation. So that one to me is right out. And I think that the state's brief is maybe arguing that materially misled a law enforcement officer, but because concealed his identity. But that would just be misled an officer. We need to know why it's relevant. What does it matter?
That person's name is not material to
To what?
anything.
No, I mean, they have, and this isn't really, I didn't brief it, but I just think it's kind of interesting. There is a false statements that's in that same, so this is 11.3, I think false statements 11.2, where they talk about just lying. But they specifically, that statute is about like lying in a government proceeding, under oath, things like that. It's not the perjury statute, but it's underneath the perjury statute. And in that one, it specifically carves out that the false information or false statement doesn't apply in the course of an investigation into a possible commission of offense, or any kind of, if you're under investigation and you don't have an obligation to speak, then false statements are carved out. So then you'd have to file it under the 3. So you can't get it under just false statements, which would be the broader category, except in an instance where it's false information to law enforcement. Then there has to be some sort of investigation, or it has to materially mislead. So again, just telling him that you're lying about who you are, unless there's more context, the court needed more context in order to find that there's a sufficient factual basis.
The statute uses the term may mislead or may interfere. It doesn't have to mislead. It doesn't have to interfere.
Sure.
The court's cases generally recognize that a district court, in taking a factual basis, can rely on reasonably drawn inferences from the evidence or record before it. As a passenger in a vehicle, could the district court rely on an obligation that the passenger had to identify themselves, for example, under the traffic code?
No. I mean, as a passenger, he actually should be just free to leave. Like, what are they doing? What do they need him for? If they're holding him for some reason to ask him questions as the non-driver, what for?
What about the discussion I think it's in the change of plea transcript where the defendant talks about being on probation in another state or on parole in another state?
He was brought, he was in custody and he was extradited over. So if I'm remembering that discussion, unless you want to point me to the right spot, he's talking about his time that he spent on hold to get over to North Dakota, and basically,
Okay.
Are they going to count his days? I think that's the discussion that you're referring
But
to.
when he was pulled over as a passenger, was he on parole or probation?
I don't know. It's possible, Your Honor. I'm not sure. The record doesn't say that. Again, that's my point, is that if there's some investigation or if there's some material reason they need to know who this is as a passenger in a vehicle, that should be in the record. It should be easily determined why we need this information.
What would the purpose of giving a false identification to police be if it's not to interfere or mislead the police officer?
Well, and the state's brief points it out, like that he is wanting to conceal his identity. Okay, but that you still need his intention. Is irrelevant, other than to prove that he knowingly did it, that he knew it was a lie when he said it. But other than him knowing it was false, the rest of the statute is on the officer to explain what's the investigation or how he was materially misled. Just that'd be the same as if he didn't give him a license but just said, "My name's John Smith." And that was a lie, and he knew that was a lie. Quite frankly, it'd be the same if he said, I have superpowers. That would also, and he knew he didn't, that would also be a lie. How is that relevant to what the officer, how is that material? I shouldn't say relevant. How is that material to what the officer is doing? Why did it, in what context, again, we need context to why this is material or may have materially misled him. Just because it's a lie, and just because it was an intentional lie, doesn't get you there. That's only half the statute. The other half of the statute is how were the police affected by this lie? And it doesn't, you're right, they don't need to show that they were categorically impeded, I guess would be the best way to say it, but they have to show that they may have been. And I think the context there is that, they changed the statute. It used to be, had more teeth, and it was not may. It used to be, it had to materially mislead, and then the legislature changed it to the may language. And I think that's when you had cases where an individual would give a fake name, and then 5 minutes later give them the real name. And so I think that would be falls under the may materially mislead, where, they've corrected fairly quickly. It still wouldn't matter under the newer framing of the wording, whereas at the old framing, I think that you had more of an argument to make, well, it didn't actually materially mislead them because of the short time in which they corrected themselves. But regardless, it's all academic because none of that's in this record. I couldn't tell you why they needed to know Mr. Boynton's actual name. I don't know.
Ms. Krausberg, this is brought under obvious error.
Yes.
And under the prejudice prong. How do you reconcile the holdings in Little Ghost and Haskins as to prejudice? Which one does this fall under and why?
I think it's Little Ghost because it's essentially the same type of argument, and it was my argument. So I mean, I'm more. And what was the other one? Oh, Haskins was when the court, it was post-conviction. So that's also different. So Little Ghost was direct appeal. Haskins, I think if I'm saying that right, was post-conviction. And so the petitioner in Haskins actually testified and never once during this testimony said, well, I would withdraw my plea. So that, I think, is the main factual difference is that you have at a post-conviction hearing where, one, he's a petitioner, so he bears the burden of showing, like, this harmed me under prong 2. And he never once indicated that he would have withdrawn his plea. Whereas the obvious error here is more akin to Little Ghost, where we're saying on direct, the court erred by accepting this factual basis. And the problem with needing some sort of supplement to the record on direct appeal is that we're actually this is sort of mandatory that the court does the proper colloquy under Rule 11, because then that's the only way to know that the defendant made a knowing, voluntary, intelligent waiver. And so case law says where we don't have the appropriate discussion with the defendant, where we don't have a factual basis, where we don't go through the elements of the offense, that we don't know that there's a voluntary, intelligent, knowing waiver of your right to trial. And you don't really even need to go to post-conviction on this. This is should just be remanded because there's just not a sufficient factual basis to support the change of plea. Which is, again, that's a court error that has nothing to do with defense. I mean, you could also argue that it's, the attorney's obligation to point it out or not let his client plead out to something that doesn't have a factual basis. But really, we don't want to raise those ineffective claims here on direct when we can clearly see that the court made an error and it can be corrected. The correction would be to withdraw his plea, and he would go to trial, or potentially, I suppose, he could get into a new, if there was more context and they added that, he could potentially get into a new change of plea, or if there was no additional context and literally it was just him providing a false name and there was no investigation and didn't really materially mislead anyone, or may have materially misled any officer, then you just don't have a charge, and it would be dismissed. So those are kind of the three options. He's either just going to go to trial, where maybe he'll make the same motion to dismiss based on what I'm arguing, or there's more context that we just don't know of because it's not present in this record, that would be provided to the district court, and so you could potentially get into a new change of plea. I don't know what's going to happen, but I do think it should be reversed. I think Little Ghost was a reversal, and I think he got back into a change of plea. I think that was the outcome. Not doing as much district court work, I'm not 100% sure on that, but so I think I answered the question as to different factually why I think this is more Little Ghost than Haskins. I think that's the one. Unless there's any other questions, I think this was a short one, but I think it's very clear from the record that you need a factual basis, otherwise the court has committed an error. That error is obvious based on our case law, most recently Little Ghost, and then a reversal is required. Thank you.
Thank you for your argument this afternoon, Ms. Kraus-Barr. This case will be taken under advisement, as all cases are, and this court will be adjourned until 9:30 a.m. tomorrow, May 28th, 2026.
All rise.